Jamaican dancehall legend Vybz Kartel has had his murder conviction overturned in the UK after the Special Justice Privy Council heard his case. This is a very unusual series of events. I've never seen anything like it because obviously due to the history of Jamaica being part of the Empire and later being part of the Commonwealth, if they appeal so far down the system, they would eventually be able to get a court hearing with the Privy Council, which is the equivalent to your case being heard by the King of England. The footage that we're going to show in this video is going to be the whole case that was heard in the Supreme Court. And Vybz Kartel's conviction for murder has been overturned after a decade. He was first arrested in 2011, and the London court ruling attempts to say that the jury was tainted because one of the jury members had been accused of trying to bribe other members during the trial, but the judge didn't stop the trial and he didn't actually get rid of that juror. That juror was later arrested and charged in relation to perverting the course of justice, but Vybz Kartel was never arrested in relation to that. He was trying to pay off members of the jury to find Vybz Kartel not guilty. After a 64-day trial, which was the longest in Jamaican history, he was found guilty along with several other men, and he was jailed for 35 years. It was reduced to 32 years after an appeal, but it was only last month that himself and his co-defendants mounted their final possible appeal at the Judicial Committee of the Privy Council that is in London, the final court of appeal for Jamaica and other Commonwealth countries. Their lawyers argued the trial judge wrongly handled the juror and also as well evidence that was used in relation to communications. They obtained information that was illegal in Jamaica, and the judge said that it was okay to have this in court, but this was later said by the Privy Council to not be the case. So that means that Vybz Kartel, in the eyes of the UK court, is not guilty of murder. And what will happen now is it will be referred back to the Jamaican court to see if he should be retrialed for the original case. And of course, some people will be thinking, well, of course, Jamaican courts are going to want to have this big trial as well. But at the same time, they have to understand that this second time round will be a lot more complicated. And it would also look really bad if they don't get a conviction. It may actually be better for them and more beneficial if they just sort of say there was a jury error and that they just leave it at that. But of course, the justice for the family of the man that was dead is still looking to be found. So this will be really interesting to see how this story develops. And we'll definitely keep you updated on anything to do with this. I'm going to leave you the footage from the actual Privy Council now to actually show you what occurred today and the outcome of this appeal. So really appreciate you joining me today. Please don't forget to like, comment, share and subscribe, and follow on social media as well at Scarcity Studios. I'll be back again very shortly with some more news. Peace.
Judgment in the matter of Shawn Campbell, Adidja Vybz Kartel and Andre St. John against the King.
On the 13th of March 2014, following a 64-day jury trial in the Home Circuit Court in Kingston, Jamaica, the appellants, Shawn Campbell, Adidja Palmer, Kahira Jones and Andre St. John, were convicted of the murder of Clive Lizard Williams, to whom I shall refer as the deceased. At trial, the prosecution case was that the deceased and another man, Lema Chow, had been given 2 unlicensed firearms belonging to Palmer for safekeeping. On the 16th of August 2011, Campbell summoned Chow and the deceased to Palmer's house after they had failed to comply with Palmer's deadline for returning the weapons. The prosecution alleged that they were met on arrival by Palmer, Jones and St. John, and that Chow and the deceased were both attacked, after which Chow saw the deceased lying motionless on the ground with Jones bending over him. Chow escaped, but the deceased was never seen again. Police attended Palmer's house on the 22nd of August 2011. They noticed the house smelled of disinfectant. On the 25th of August, they cordoned off the perimeter wall, treating the premises as a crime scene. When they returned on the 27th of August, they found that the entire interior of the house had been destroyed by fire. On the 29th of August, police forensics reported a foul odour emanating from the living room. On a further visit on the 30th of September, it was discovered that the rear of the house had been demolished. Police dug at the premises but did not find a body. The police seized the mobile phones of Palmer and St John. Text messages, voice notes, and a video from those phones were put in evidence at trial. The prosecution also relied on telecommunications data which the police had obtained from Digicel, a communications provider. The prosecution case was that the mobile phone evidence and telecommunications data, taken as a whole with Chow's evidence, proved the fact of the killing, the reason for the killing, the method of disposal of the deceased's body, and the identity of at least one of the killers, namely Palmer. The four appellants each denied murdering the deceased. At trial, the appellants objected to the telecommunications data being admitted as evidence. They argued that the data was inadmissible because it had been obtained in breach of the Interception of Communications Act and the fundamental right to the protection of privacy of communications guaranteed by the Charter of Fundamental Rights and Freedoms contained in the Jamaican Constitution. The judge admitted the evidence. He ruled that the data could be relied upon by the prosecution even if it had been obtained in breach of the Charter or the Interception of Communications Act. Over the course of a 64-day trial, there occurred a series of incidents involving the jury. The jury was reduced to 11 members after a juror was discharged almost 8 weeks into the trial. On the final day of the trial, it was brought to the judge's attention that a member of the jury, who will be referred to as Juror X, had attempted to bribe other members of the jury. The judge questioned the jury forewoman, who stated that Juror X had offered bribes to each of the other jurors to acquit the appellants. The judge asked counsel for the prosecution and the defense if the trial could continue. It would not have been possible only to discharge Juror X, because under the Jury Act, a trial for murder cannot continue with fewer than 11 jurors. The judge decided to proceed with his summing up and gave a direction to the jury, reminding them of their function. The jury retired to consider its verdict at 3:42 p.m. The jury returned at 6:08 p.m. and by a majority of 10-1 convicted all four appellants of the deceased's murder. A fifth defendant was unanimously acquitted. Juror X was immediately arrested and was later convicted of attempting to pervert the course of justice. There was no evidence to connect his activities with the appellants. The appellants appealed against their conviction to the Court of Appeal of Jamaica, which dismissed their appeals. The Court of Appeal granted permission to appeal to the Judicial Committee of the Privy Council on 3 grounds, which were, first, that the trial judge failed properly to inquire into allegations of juror misconduct; secondly, that the trial judge departed from standard practice in inviting the jury to retire to consider their verdict so late in the day, putting undue pressure on them to reach a verdict; and thirdly, that the trial judge erred in admitting the telecommunications data because it had been obtained in breach of the Interception of Communications Act and the Charter. The Judicial Committee of the Privy Council has unanimously concluded that the appeals should be allowed and the appellant's convictions should be quashed on the ground of juror misconduct, and that the case should be remitted to the Court of Appeal of Jamaica to decide whether to order a retrial of the appellants for the murder of Clive Williams. The Board has considerable sympathy with the dilemma faced by the trial judge on the final day of a long and complex trial. Following the allegations of bribery, he had either to continue with the 11 remaining jurors or to discharge the jury. Despite this, the Board considers that the approach taken by the judge was a material irregularity in the course of the trial, which makes it necessary to quash the convictions. This is for 3 reasons. First, the direction to the jury on the final day was inadequate to save the situation. The judge simply reminded the jury that they had sworn or affirmed that they would return verdicts in accordance with the evidence they had heard in court. The judge did not refer to the alleged bribery, of which If the allegations were true, the jurors were already aware. Secondly, the trial continued with the allegedly corrupt juror serving as one of its 11 members. In the board's view, there should have been no question of allowing juror X to continue to serve on the jury. Allowing juror X to remain on the jury is fatal to the safety of the convictions which followed. It was an infringement of the appellant's fundamental right to a fair hearing under the Jamaican Constitution. Thirdly, the judge should have considered whether the remaining jurors might have become, consciously or unconsciously, prejudiced for or against one or more of the appellants as a result of juror X's behavior. For example, there was a danger that the attempted bribe could have made the other jurors overcompensate, consciously or unconsciously, if they assumed that the offer must have come from one of the appellants and that therefore they must be guilty. The judge took no account of this risk. The board is very mindful of the serious consequences which may flow from having to discharge a jury shortly before the end of a long and complex criminal trial. It is also very conscious of the danger of deliberate attempts to derail criminal trials by engineering situations in which it is necessary to discharge the jury. In England and Wales, there is legislation which allows a judge in certain situations to discharge a jury because of jury tampering and to continue the trial by judge alone. There is no such legislation in Jamaica. It follows that there will be occasions where, as in this case, a court will have no alternative but to discharge a jury and end the trial in order to protect the integrity of the system of trial by jury. In view of its conclusion on the issue of juror misconduct, the board holds that it is not necessary to express a concluded view on the other two grounds of appeal. For these reasons, the appellant's appeals should be allowed. The court is now adjourned.
Settlers.